Now we're going to get down to the nitty-gritty of what Indians are all about.
I still say we Indian people are believers in the truth. This is the way of life that was given to your people. You're born an Indian, you're going to die an Indian. Indianness is a good life. You're facing an Indian this afternoon.
This court has always asked in that regard is whether Congress also meant to go beyond that and alter reservation boundaries. And here, where we simply are talking about the allotment and the opening up of small town sites to non-Indian settlers, that falls squarely into the rubric that this court has designed, where reservations have remained intact. With respect to sovereignty, if a sovereignty was to be completely divested, and that's not what happened here, but if it was, I think the question this court would ask is whether the federal government still meant to maintain the reservation for its own purposes. If it didn't, then the reservation would dissolve. Here, if the tribe had been dissolved, the treaties make very clear that the reservation itself would have evaporated. And I understand this is not the premise of your question. That is not what took place here. The 1901 and 1906 Acts clearly maintained a quantum of tribal governmental power. Thank you.
Justice Ginsburg?
If you are right, and what becomes of all the state tribal cooperative agreements that we're told about? If the state lacks authority to apply its own law within Creek territory, remaining as a secession state, that everything except what was in Civil War. All of the, we're told that there are many state tribal cooperative agreements, but if the state lacks authority to apply its own law, what becomes of all those state tribe cooperative agreements?
The agreements, Your Honor, will remain in full force and effect, and this is critical. If we prevail, state law does not evaporate from the reservation. Under this court's doctrines, state law applies in many situations with respect to, especially with respect to the non-Indians in the area, and that's what leads to these cooperative agreements. Reservations involve the different jurisdictions all having authority, and that has been the premise of shared jurisdiction has underpinned these cooperative agreements. And the best thing I can point you to is not my words, but the words of Congressman Cole's brief, and that's a remarkable brief. I think very few briefs like that have been filed in this court in the area of state-tribal relations, where you have senior members of Congress, former governors, former state legislators saying, please do not disestablish this reservation, because the exercise of tribal sovereignty in cooperation with the state has underpinned these agreements. And the authors of that brief were the authors of many of the agreements on the state side, and it's this premise of shared jurisdiction that has allowed for shared governance in Oklahoma to the benefit of all citizens there. And
thank you, counsel. Justice Breyer?
So I'm still interested in this claim that the state makes that whether it's a reservation or not a reservation is beside the point. But all we have to decide here is whether Congress gave to a state court the power to try the state criminal crimes. And Felix Cohn points to three things where he thinks the answer to that question is yes, seems to. First, they abolished tribal courts and put the criminal jurisdiction in the Indian court, the Indian territory courts, which were federal courts. Then in the 1906 Act, it says that those territorial courts, which were federal, have the power to try state law cases. Now, they're not called state law cases then, they're called laws of the territory of Oklahoma. And then in the 1907 Act, which is after, with the Enabling Act, it says all causes, civil or criminal, shall be proceeded with, held and determined by the courts of the state coming about, the successors of the district courts of the Territory of Oklahoma and the United States courts in the Indian Territory. So it's rather ambiguous, this last thing. But given the practice, and given Felix Cohen, and given you could read it that way, what do you think?
Your Honor, it would make my life much easier in this case if I could say there was plain text that had transferred jurisdiction of the state over the Indians. As you know, there would be nothing inconsistent with that and reservation status.
Oh.
But we simply can't find that text. I think the operative text is, as Justice Alito said, ends up being the amended Section 16 of the Enabling Act. Prosecutions for all crimes which, had they been committed in a state, would have been cognizable in the federal courts.
Justice Alito? Justice Alito? Justice Sotomayor?
Counsel, could you finish your answer to Justice Breyer, please?
Absolutely, Justice Sotomayor. The cases that would have been cognizable in federal court if Oklahoma had been a state included prosecutions under the Major Crimes Act or the General Crimes Act. The Enabling Act is very clearly saying that those are to be transferred to federal court. As to the practice, this is critical. Nationwide, around the nation, states were arrogating criminal jurisdiction to themselves, and the federal government was abdicating it, even in cases where the reservations clearly remained intact. That happened in South Dakota, the Solon case. That happened in Nebraska, the Parker case. That happened in Washington State, the Seymour case. That happened in Mississippi, the United States v. John case. In all four of those cases, this court unanimously, across different eras, different compositions of this court, paid no heed to that practice. For this fundamental reason, the acts of executive branch officials cannot subvert the will of Congress. Those acts of executive branch officials do not run the gauntlet of bicameralism and presentment. And here is all the more reason not to pay those heed. We know that federal officials were subverting the will of Congress in Oklahoma. After statehood, they would not allow the Creek Nation to hold elections for its chief, its national council, even though the Five Tribes Act clearly preserved those powers. So why we should pay heed to the acts of federal officials when they were clearly acting illegally is something that the state has never explained.
Counsel, could we go back to Justice Thomas's question? Am I to understand that in existing reservations outside of this Creek Nation issue, there are fee simple possessions by non-Indians? Non-Indians are living, working on those reservations. And am I to understand there's concurrent federal, state, and Indian jurisdiction over many of the issues involved with those people?
Correct, Your Honor. Wherever there's fee simple land in a reservation, there is concurrent jurisdiction.
So you really can't tie...
So, Justice Alito?
Am I correct that more than 90% of the people who live in the area directly affected by this case are not members of the Creek tribe?
That is correct, Your Honor.
Well, what would you say to those people if we decide this case in your favor? Won't they be surprised to learn that they are living on the reservation and that they are now subject to laws imposed by a body that is not accountable to them in any way?
There are a number of responses, Your Honor. First, very little will change for them. Certainly, very little to the bad will change for them. They will largely remain subject to state law. They will benefit in significant ways from reservation status. Justice Breyer asked a question at the last argument about the Tulsa businessman. Well, that businessman could wake up the day after the argument and qualify for enterprise grants that attach to reservation status.
What will be the extent of the tribe's authority over these non-Indians? For example, if any member of the tribe has a contract dispute with a non-member, say it's about an employment contract or a lease or the purchase of goods, will the tribal member be able to sue the non-Indian in tribal court under tribal law?
No, Your Honor. Assuming that this takes place on fee lands, which is, as you've noted, the majority of lands in the reservation, under this court's precedents, it's clear that absent affirmative consent, no, that case would proceed in state court. The tribal law presumptively would not apply to non-Indians with respect to activities taking place on fee land.
Well, if this were a different reservation and a non-Indian chose to do business there, knew that he or she was entering a reservation and was doing business there, that would be considered to be consent, would it not?
Yeah, well, this court's precedents are honestly a little unclear on that, but if there was some form of affirmative expression of consent, that would bring the case within tribal jurisdiction.
But there will...
Justice Kagan?
Mr. Kenji, could I ask you to continue, and you're talking about the consequences of this, and focus particularly about adoptions and foster care proceedings, because I know there's been some concern about that.
Thank you, Your Honor. There's been some, frankly, rhetoric about that, but it's misplaced. On the ground, the state agency, the Health and Human Services Agency, and the nation cooperate in every ICWA case. They have a terrific relationship, and they have both been involved in the placement of Indian children. That will not change if the reservation boundaries are affirmed. There are various mechanisms to formalize those agreements. Section 1919 allows the state and the nation to continue sharing jurisdiction, for the state courts to retain jurisdiction where there are existing placements, or under Section 1915 for the nation to ordain those placements. There is simply no cause to think that existing placements will be disrupted. That is not in the interest of the nation, the parents of the children, and it will not happen.
And with respect to all of these disruption questions, what role do you think that our decision in City of Sherrill plays?
Well, Sherrill Sherrill is always in the room when the states and the tribes are negotiating agreements. It's really, honestly, a thumb on the scale on the side of the state. So when it comes to all the fabric of cooperative agreements we have in place currently, those will continue. We have terrific working relationships, as the Cole brief exemplifies, and it will continue to play that role. Now, if there were ever a situation where the nation were to assert sovereignty in a way that went beyond the bounds of those agreements, and that the state took umbrage with, Sherrill is an arsenal in the states that the states can employ in those situations. So what Sherrill makes very clear is that there's a clear distinction between reservation boundaries and whether they exist or not, and what equitable defenses might apply to the assertion of tribal authority within those boundaries.
Justice Gorsuch?
Counsel, there's been a fair amount of discussion so far this morning about the Oklahoma Enabling Act and the suggestion that it's inconceivable that Congress would have admitted a new state to the Union where a significant portion of the state would have been a federal reservation subject to the Major Crimes Act. And I'm not sure we've given you all a fair chance to have at that, so I'd appreciate a thorough response to that question.
Thank you, Justice Gorsuch. There's nothing inconsistent between the advent of statehood and reservation boundaries. The Solemn case makes that patently clear. The Cheyenne River Reservation and the Rosebud Sioux Reservation were ordained 8 months before statehood. Congress clearly, and they accounted for about 10% of the state's land mass alone. Congress clearly understood at this time that states could come into being with significant reservation masses. Arizona became a state shortly after Oklahoma. That was 27% of the state's land mass. This court, by that time, had recognized that state jurisdiction in the criminal area and the civil area could pertain to non-Indians on reservations, and had established this framework of concurrent jurisdiction that still persists to today.
Thank you, counsel.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning. As I mentioned in the last comment, I think we have to understand what the situation was as of 1890 to understand the text of these statutes, but I want to focus on the text. In particular, the text of the statute that abolishes the tribal courts and the text of the statute that creates, in essence, municipal towns within Indian territory during the 1890s. and what the significance of those two statutes are for assessing sovereignty, because ultimately the question, as Justice Thomas suggested, I think, is what's the status of legislative, executive, and judicial power? How should we think about those statutes with the tribal courts and the municipal towns?
Mr. Chief Justice, I need just 1 minute to answer this question because it's critical, and it's an excellent question, Justice Kavanaugh.
That's exactly how much time you have.
Thank you. With respect to the courts, it's critical to remember most tribes did not have tribal courts at this period of time. It was a rarity that the 5 tribes did. So in restricting and then eliminating those tribal courts, Congress was merely putting them on the same plane as other tribes. And then more generally speaking, with respect to the quantum of governmental powers, as you know, Justice Kavanaugh, Congress has regularly adjusted the metes and bounds of tribal sovereignty. That's what this court recognized in Lara, but has never equated the quantum of power with the existence of the reservations themselves. And it's this
on the tribal courts point, the difference, I think, some would say, is that the other tribes were not governing a jurisdiction that was predominantly non-Indian, which is what was going on here. Any reaction to that?
Yes, look at exactly what happened in 1901 and thereafter with the Allotment Act. The tribal courts were gone, but the Secretary of the Interior continued to enforce the tribe's legislative authority. Section 42 made it very clear that that legislative authority persisted. The Secretary enforced the tribal laws, and this court's decision in Hitchcock and the Eighth Circuit's decision in Buster make it crystal clear that the tribe's legislative authority persisted after the acts in question were enacted.
Thank you, counsel. General Mansinghani.
Thank you, Mr. Chief Justice, and may it please the court. Oklahoma has jurisdiction over the eastern half of the state because it never was reservation land and is certainly not reservation land today. To start, the land was not public land reserved from sale, where title remains with the United States, but instead patented in fee to the Creek Nation. That is why this court in U.S. v. Creek Nation called it a former dependent Indian community. And under Venati, it clearly lost that status when the fee patent was dismantled. Now, assuming the land was a reservation, Congress stripped away all semblance of reservation status. Solemn asks us whether Congress's purpose was to divest the tribe of all its interest in the land. And here, statute after statute did precisely that. The Curtis Act ended tribal governance of the land. The allotment agreement divested the tribe of all its right, title, and interest. And even allotments were quickly stripped of federal superintendents. Everyone at the time read these statutes to mean the state had jurisdiction and the land was not a reservation.
Thank you, counsel. Mr. Gershengorn, in response to a question from Justice Kagan, argued that dependent Indian community was an umbrella term that included reservation. I'd like to get your response to that.
I think that definition would completely make 1151B surplusage. It would read it right out of the statute. What this court said in Venati is that tribes with land and fee are, quote, unlike Indians living on reservations, citing Sandoval, which compares the Pueblos, who had a dependent Indian community, as essentially the same as the 5 tribes. And in Creek Nation, this court said that the 5 tribes had a fee simple, not the usual Indian right of occupancy, which is what is typical of reservations, and it was a dependent Indian community. And then Congress went out and codified Sandoval as a type of land status separate and apart from reservations, which is what this court held in Venati.
Thank you, counsel. Justice Thomas?
Yes. Counsel, I'm very interested in your point that we should characterize this as a dependent nation. First, I'd like you first to say why you think that and why it matters. And opposing counsel seems to think that it's irrelevant, and as he said, as I recall, that it's also wrong, your assessment of that. So it gives you an opportunity to both respond to that and to explain to us why it is important.
So why it is a dependent Indian community? First, as I said, the Venati said that tribes holding their land under restricted fee are unlike Indians living on reservations. Sandoval and Creek Nation confirmed that. And as far as it doesn't meet the definition of a reservation, I'll take the definition from Hagan v. Utah. Land belonging to the United States that is reserved from sale and set apart for public uses. And in Pine River, this court said reserved from sale means the fee remains in the United States. Well, issuing a fee patent is not reserving from sale, it's selling it. Why it makes sense. Making land alienable to non-Indians in a dependent Indian community ends the dependent Indian community status. That's what this court said in Venati, and that's what then Judge Gorsuch at the 10th Circuit said in Hydro Resources on page 1163 and footnotes 11 and 30 of his opinion. And that makes textual and logical sense because there's a textual difference between 1151A, which says that a reservation remains one, notwithstanding the issuance of any patent, and 1151B, which doesn't contain that language and defines dependent Indian communities. Again, Judge Gorsuch pointed that out in Hydro Resources. It also makes logical sense because if what created the land was the fee patent, the opposite of that, the conveyance of the fee patent, disestablishes. That's in accordance with this court's decision in Hagan v. Utah, where it said reservation is reserving land from the public domain, so restoring land to the public domain ends the reservation.
Justice Ginsburg?
If the reservation had been disestablished, would the tribe have any governing authority? And if so, over what? Would the Major Crimes Act apply, or would exclusive prosecutorial authority for state crimes lie in the state court?
So the tribe would have their governments in that they would have control over their own internal affairs and managing their property interests, which if you look to the tribal understanding at the time, as you quote in our respondent's appendix, is exactly what the tribe understood their own authority to be. As far as would they have any authority over land, there is some land that is under their original fee patent. So the River Spirit Casino in Tulsa is built on the riverbed of the Arkansas River because that land was never allotted. So they have governing authority over that land, over trust land, and over restricted allotments, but we think the state nonetheless has jurisdiction over all of the state pursuant to the transfer of state to state jurisdiction in the Enabling Act, which, you know, what Congress had done in the Indian Territory is say the Indian Territory is an area where Indians and non-Indians are treated alike. And the Enabling Act in Section 21 extended federal law except where locally inapplicable. And it was the Major Crimes Act was locally inapplicable in the Indian Territory because the 1897 Act is the act that conferred jurisdiction, not the Major Crimes Act, which is why petitioner can't cite a single Major Crimes Act case during this period, before statehood or after.
This question was asked before, but what of the congressional prescription that in Oklahoma all residents are subject to the same law irrespective of race?
I think that lays the framework of what Congress was trying to do in creating the state of Oklahoma, which was to transform the governance of the state and the land ownership of the state, which was exclusively tribal, to a place where both Indians and non-Indians could both own land and be governed by the same state government. If you look at pages 22 to 25 of our brief, we lay out that history and lay out that is what Congress said explicitly in legislative reports. That's what the Dawes Commission report said, and that's what the tribes recognized in their own tribal understanding.
Justice Breyer.
No, thank you. I'll pass.
Justice Alito? Justice Alito?
Yes. Mr. Gershengorn has a section of his brief that's labeled "The Sky is Not Falling," and his argument is that you and the federal government are exaggerating the effect of this decision, that it won't have such a major impact either in the criminal or in the civil area. Is he right in that?
No, Justice Alito. So let me let me put some solid numbers on this. We have currently over 1,700 inmates whose crimes were committed in the former Indian Territory who identify as Native American. So the state presumptively would not have jurisdiction over those people and have to release them. And that is probably half the actual number because it doesn't include crimes committed against Indians, which the state would not have jurisdiction over. So we're talking here about potentially around over 3,000 inmates we may have to turn over. As far as future cases go, there were 32,000 felonies committed in the former Indian Territory, an area that is about 12% Native American. So only including crimes committed by Native Americans, that'd be 4,000 new felonies a year that the federal government would have to prosecute, including crimes where the Native American is the victim. You can take that to about 8,000. On the civil side, what happens is it creates precisely the differential legal treatment between non-Indians and Indians that Congress tried to abolish when it created the state of Oklahoma. So non-Indians would not be subject to presumptively to state zoning law, to dog law, as Justice Breyer mentioned, and that creates a disparity between Indians and non-Indians. So now non-Indian businesses are competing on an unequal playing field with Indian businesses. That's just one example. The Tulsa brief points out examples of, on restricted allotments, how Indians are erecting billboards in residential neighborhoods or selling fireworks in them, but that's in the few areas, the 2% of land that remains restricted allotments. If the entire area is a reservation, then you're creating the two separate societies that Congress had sought to abolish when it passed the dozen statutes it did in creating Oklahoma.
Justice Sotomayor?
Counsel, with the latter part of all of the parade of horribles that you set forth, Congress can come in and change all of that. Congress can give the state jurisdiction over anything it might be missing. If we were to hold this was a reservation, they have done so with respect to many other reservations across the country. So this is easily fixable by Congress. Putting that aside, what do we do with the treaty language here that resulted after the Trail of Tears with the Creek Nation? That nation was wrenched from its homeland, marched to Oklahoma, and then given a treaty as recompense which guaranteed its sovereignty. I'm not sure that there's any other dependent Indian community that depends on a treaty right that extends or recognizes sovereignty. So can you point to any? Number one. Number two, if there isn't, why aren't we back in Solomon and Parker? Is there anything explicitly that terminated the reservation in the history that you've recounted?
Let me try to take those questions in order. Congress can't fix the retroactive consequences here. As far as the dependent Indian community, I think the Pueblos have sovereignty over their land. It may not have been via treaty, but the idea that the dependent Indian community versus reservation turns on treaty rights is actually nowhere present in this court's case law. And on top of that, would actually undermine lots of reservations that were not created by treaty but by executive order. So petitioner's position would actually undermine Indian country around the country.